To date, Simon and Luke have focused on summary judgment and on the overarching obligations. What I really want to speak to you about is using the Civil Procedure Act to augment the rules of court or the powers the court has had. There's two different ways that this occurs in the Act. The first is there are some broad powers given to the court. And when I say court, that means the Magistrates' Court, the County Court and the Supreme Court. It does not apply to VCAT or other proceedings, but there's powers given to the court, and that's something that I think that people sometimes forget. Now, you've heard and you will hear and you'll continue to hear about the just, efficient, timely and cost-effective resolution of the real issues in dispute. That's the overarching purpose, and it's the touchstone for everything else in the Act. What happens, though, is in recent times, people have started to realise, or appellate decisions have started to explain that that isn't just a motherhood statement, it's a touchstone which actually grants the real powers to the court. The way it does that is through the combination of Section 7, 8 and 9 of the Civil Procedure Act. Now, Section 7 is the overarching purpose. Section 8 provides that a relevant court must seek to give effect to the overarching purpose in the exercise of any of its powers or its interpretation of those powers. And those powers can be powers given to the court via the common law, practice notes, the rules of court, the inherent jurisdiction, all those different things. So whenever exercising those powers, the court must keep all of this in mind, and that really offers a great opportunity to creative or sensible practitioners to the extent that old authority requires you to find strange notions of equitable jurisprudence to put an argument or to found a power, or to do something which really just makes sense. You don't need to start jumping through all of the same hoops you used to. Now, obviously, it's always easier to go to a practice note or to go to the rules or to go to something like that. But hopefully, a couple of the cases I'll point you to in the next few moments will demonstrate that that's not strictly necessary and that on some occasions it should actually be avoided. So you've got Section 8 there, which says that the court must seek to give effect. Section 9 illuminates, and it's expanded on in the paper in paragraph 49. I don't want to take you through it, but it gives the court a number of objects to consider when considering this, and some of those objects include matters such as the efficient conduct of the business of the court or the efficient use of judicial and administrative resources, timely determination of proceedings. And some of the cases which have been decided on the Civil Procedure Act really do emphasise that. There have been a number of cases that have come before the courts where the parties have argued both for something and the court has come to a different view as to what the procedural order should be, because they don't want their list stuffed around. They don't want to push something off, even though both parties will say that they take a particular view on a subject. Sometimes those views from the parties are the same, sometimes they're diametrically opposed. But as far as I'm concerned, and strangely in this situation, the key decision is actually on these provisions is not actually a decision on the Civil Procedure Act, the Victorian Act. It's actually a decision by the High Court from last year concerning the New South Wales equivalent. The case was Expense Reduction Analysts and Armstrong Strategic Management, and it's discussed in paragraph 50 onwards of my paper, or of our paper. Apologies.
You're only told or something.
Section of the paper. Really, some of you may have heard of that case. It comes back to an all too familiar theme in modern litigation of major discovery. I think there was something like 600,000 documents that had to be reviewed. As is often the case, it was left to some junior lawyers in a large firm to electronically review things, and they forgot to click the privilege box on a number of documents. Ultimately, what happened was they wrote to the other side when they recognised their mistake, and the other side said, no, we don't have an obligation to give those back to you, and we're not going to give the undertakings. They went to the court in New South Wales and they said, we want an injunction returning these documents. The court started to do as it does, look for its power. What followed was 3 days of hearing on the subject of 13 privileged documents, discussing equitable obligations of confidence and whether there was a power to grant an injunction in these circumstances and all of these issues. The matter then went to the High Court, and there was some UK authority and some older UK authority which questioned the powers of the court, and ultimately no injunction was granted. There were complex questions of waiver, whether privilege, whether there'd actually been a mistake, and all of these various different things. And then the matter got appealed to the High Court. The matter came before the High Court, and there's a quote in paragraph 50 of the paper, and I think it's an important quote, and really it just harks back to Aon. And we all know that Aon concerned the civil procedure rules in the ACT, but that hasn't stopped it applying in Victoria and in all sorts of other jurisdictions. It really was a pronouncement from the High Court that case management has changed and that we need to do things differently. And I see this as being a similar sort of pronouncement. They say proceedings of this kind and length concerning a tangential issue should have been averted. There was no need to resort to an equitable action in the equitable jurisdiction of the Supreme Court to obtain relief. The court has all the necessary powers to deal with the issue relating to discovery. And they go on to say, those powers exist by virtue of the court's role in the supervision of the process of discovery and the express powers given by Part 6 of the Civil Procedure Act, and that is the New South Wales Act, to ensure the just, quick and cheap resolution of the real issues in dispute in the proceedings. Now, the acts aren't identical, but effectively the same provisions where you've got overarching purposes, and you'll see that overarching purpose is very similar, and you've got other provisions of the Act which require the court to give effect to that purpose. And then you've got specific powers which relate to various areas such as discovery as well. But what they've really done there, later on they went on and pointed out that the expectation of the Civil Procedure Act is that the court use these broad powers to facilitate the overarching purpose. And they reiterate that the proceedings are now firmly in the hands of the court. It's not a matter of the practitioners both turning up to court and saying, okay, this is the way we want things done. The court should actively case manage things so that they achieve the goals of the Civil Procedure Act, and they specifically state that purpose may require a more robust and proactive approach on the part of the courts. And anecdotally, in my own experience, that is actually starting to occur through some judges. There will be times where nobody will mention the Civil Procedure Act and a judge will, or a magistrate will mention it. Now that's certainly not across the board, but it is starting to occur. To the extent that there was any doubt about the applicability of that decision in Victoria, that was quickly dispelled by the case of Eaton, which was the Court of Appeal decision which was mentioned before. I don't really want to go through that case in great detail. I touched through on it in paragraphs 53, 54 of the paper. Suffice to say, the court goes through sections 7, 8 and 9 of the Act. They go through Aon, they go through expense reduction analysts, they mention all of those things, and they really say, look, this needs to be applied. And to drive that home, they say the overarching purpose applies to the court in the exercise of any of its powers, however they may arise, including all powers under any procedural rules or practices of the court. So that's a very broad explanation of the legal foundation for the power. How does that actually play out in practice? Well, it can be used in many, many different ways. I sat down to start looking at the various cases and how they've applied these, and really I limited myself to a couple of examples in the paper. But I think a particularly instructive example is the case of Jura Constructions and Hugh Boutique Living. And it's, the reason that's instructive is that I've actually moved to another part, which I was thinking about another Jura at the time. Sorry, Jura is mentioned in the paper here, and it explains that case. But later on, Jura is important because when we get to the specific powers under the Civil Procedure Act, the judge was faced with a situation, it was Justice Dixon, he was faced with a situation where I think halfway through the trial, I think 17 days into a very complex construction trial, numerous objections were taken to various experts' reports. Now, he'd attempted, as he explains in his lengthy judgment, and I commend the first 30-odd pages to you. If you want to learn a little bit more about defects and the like, then you can continue to read the other 260 pages. But in terms of expert evidence and in terms of the way that he managed the process, he explains all the different case conferences and the conclaves and everything that's happened. But he says, look, eventually that's failed. I didn't want to push off the trial date. And there's a High Court decision in the case of Daz Reef from about 2011, and that really states that expert evidence should be ruled on as to admissibility. It's not the kind of thing that should all go in for weight, and then you should consider weight later on. And there's a very strong statement from the High Court that says you should rule on that at the end of the voir dire. You should rule on the admissibility at the end of the voir dire. And Justice Dixon says, I'm aware of this authority, I understand it, I know that the court says that you should usually do this, but Section 49 of the Civil Procedure Act allows me to do, make whatever directions I feel are necessary to further the overarching purpose and the like. In this case, if I took all these objections now, took them on board, ruled on every single one of them, we would not finish it in the time. That would result in having to come back in 6 months' time or a year's time because of my list. So in this case, I'm going to acknowledge what the High Court says, but use the power in the Civil Procedure Act. And I have no doubt, given recent decisions of the High Court, they would have supported that approach to things. It's sensible and it can be done. Specific powers in the CPA, again, I don't want to go through those, but parts 4.2 relate to case management. That was the provisions which Justice Dixon relied upon. There's 48 which relates to pre-trial procedures, 48, 49 which explains the conduct of trials. Part 4.3, disclosure and discovery, and again you'll see some cases in the paper where statements have been made about the way discovery has been augmented, or procedures have been augmented by the Civil Procedure Act. Now, the thing to take out of that is you can be creative. There's a particular case, again, which is mentioned in the paper, and I think we don't really have time to go through it, but it shows an example of where plaintiffs applied for an order pursuant to Section 55 of the Civil Procedure Act, which is another provision which adds to the powers of discovery. Now, often those are designed in the Civil Procedure Act to limit discovery, for people to be able to say, look, we don't have to provide general discovery. But in this case, they used it to seek an order requiring a respondent to actually provide written authority to obtain tax returns from the ATO. Now, again, this is another case where old authority was against, or at least made it difficult for the plaintiffs to do something that was very sensible. But because it wasn't technically in the power, possession or control, you needed immediate access to legal right and the like, you had to jump through a lot of hoops. They bypassed that and went straight to Section 55 of the Civil Procedure Act and said, look, this is sensible, they're fundamental documents to the case. There's an affidavit saying they no longer have them or they're not there, and the order was ultimately granted. I think what I'd like to say in conclusion on this point is that there are specific powers in the Civil Procedure Act, and there are broad powers. And as most advocates will know, and most solicitors and anybody who's been involved in a trial will know, if you can convince a judge that what you want to do is the right thing to do, then most of the battle is won. All you have to do then is give them a power to get there. And the Civil Procedure Act often represents that power. So if you think that expert evidence should be provided early, or you think that an order should be made which is contrary to some 1960s authority on the interpretation of a particular rule, make that application and direct the judge to the Civil Procedure Act. I'm going to very quickly give you my 3 key tips on life post the Civil Procedure Act. The first is to really get things right from the start and then to comply with directions. The case of Eaton in particular makes it clear that you don't just get your automatic rights to amendments or adjournments or extensions of time that you used to do. Now, sometimes judges aren't going to listen to these arguments about the Civil Procedure Act. I think that's a function of where we are in the process of this coming through, but there are enough judges out there now that really you're running a risk. If you think that you can institute proceedings and not comply with directions, for the obtainment of expert reports. Go to a mediation and then think, well, if the matter doesn't settle at mediation, I'll go and get the expert report. If the order said beforehand you have to do that, Eaton says the judge does not have to grant you an adjournment or accede to a request to file that late. The purposes were for you to be fully informed at your mediation. Now, judges can take a different view. The overarching purpose is a malleable concept and right for debate, but it's a risk now. The second thing is be proactive. Think about the ways to run your litigation in the most efficient or sensible way. At the start of the litigation, start to think about whether you need to request documents from the other side. Section 26 of the Civil Procedure Act gives an overarching obligation to disclose the existence of critical documents. I often request my instructors to write to the other side and request a few documents. They might not be mentioned in the pleading, you might not have a right to them under the rules of court, but they might be fundamental to understanding whether your client has a defence or a case, and other things which can happen. If you have we've heard a lot about fully informed mediation, that's very important, but if you have a case where it's a simple legal issue, or people are going to become entrenched by continuing to run the litigation, ask the mediation to happen straight up. I had one recently where we hadn't even put in a defence. We'd explained why the case was going to lose. Now, ultimately, we didn't settle it, but I think we got as far as we possibly could have, and we did that before we'd incurred any other costs. It was fully informed, the parties were in an intractable position. I think that the point that was made by Luke about professional conduct, I think that we do our clients and the profession no service whatsoever by blindly following past practices and rules of procedure. I think that often those rules are there for good reason. They've been built up over time and they make a lot of sense, but sometimes they don't. And we need to think about those things. I think there's a view of the profession sometimes that we just like to make fees and we're not after our clients' best interests. I don't think that's actually the case most of the time. I think that just most people don't necessarily think about whether there's an alternative way to do things or whether something is particularly needed. And if you can convince a judge that a certain direction is needed, they should make it now these days, and a lot will. The final tip is really to get creative. I think that there are situations now where you can make an application which is not based squarely on what you're going to find at the top of a Williams section on how the rule of court have been interpreted for the last 100 years. Expense reduction analysts involved 3 appeals to the ended up in the High Court with numerous sitting days. If somebody had come along and said early on, Civil Procedure Act says this, you've got the powers to order those documents to be returned, there might not have been a 60 or 80 page judgment from the Court of Appeal on equitable obligations to return privileged documents. Now, jurisprudence may be the poorer for it, but the clients will certainly be the richer and they'll be happier. And I think that sometimes that thinking about outside the square rather than just following what you've always done is something that should be done, and that's certainly being encouraged by the Civil Procedure Act. I think we should probably move on. Yeah.
Okay. We'll hand over to questions. Do we need, for the purposes of sound, etc., to have the roving mic, or we don't? Okay. I'm not going to worry about the roving mic because we can all hear you. Does anybody have any questions arising from either of the 3 talks?
Just repeat the question.
Yeah. Yes.
The comments by the Court of Appeal in the Yara case about briefing particular counsel and the conflict between the direction is that they must abide by their overarching obligations to prove possible and and even if your client tells you otherwise, your duty is to so it's troubling to a solicitor if you've got a client who says, well, I want this so-and-so to appear for me who charges X, and I'm happy to pay that. But you feel that the case really doesn't warrant counsel that seniority. And that's you're in a real bind there.
That very issue was raised at a conversation I had with some other counsel recently. That particular part of the judgment really is an interference with someone, a plaintiff or defendant's right to say, no, I want the best person. It's sort of the Kerry Packer thing from the How's That show. I want you to find me the best bloke and I'll pay him more than anyone else, and he drops everything and comes to work for me. That sort of thing. And why shouldn't people be allowed to do that? And it is troubling that can be curtailed, but I think the reality is that it can be, and it comes back to client management, which is always difficult. There are plenty of good senior juniors out there. If, for example, the argument is, I must have a silk. With great respect to all the silks out there, there are a lot of senior juniors who don't charge as much, who are probably as good, if not better, in some circumstances. And I think it's about exploring your networks, and this isn't a pitch for Green's List or anything, but finding out there are people at the bar, and I'm certainly not suggesting I'm one of them, but there are people who bat above their weight, and their track records speak for themselves, and it might be something, I raise it because it's something you can feed into that conversation with the client, letting them know. I mean, they're not really going to care about what the Court of Appeal said in Yarra, but you can just say, look, this is where it's at now from a legal point of view. But I think it's in marshalling your arguments in your client management discussions, and that's really the best you can do. What do you do if it gets to the point where you're at loggerheads?
I might just add to that. I think that whilst that's important, I think that the biggest concerns the court have are actually about the use of judicial resources and whether those costs can be recovered. So I think they're certainly conscious of that, but I think if you make the argument that says, look, we brief who we wanted to brief, they didn't waste any more time, and if you only give us the costs of a junior appearing onto the day, I don't think that much criticism can be taken. Obviously, internally, that could be a different issue, but if it's the client driving that, I think there's a slight distinction between wasting the court's time and wasting other parties' times, and I guess wasting your own client's resources, although sometimes that can be blurred in the grand statements.
I was going to say...
We've got to keep moving.
On that point, though, sometimes judges say it's better with a silk because it just goes faster and it's easier for them to write the judgment. So I don't know how much pushback you'd get, assuming it was justified in the context of the case.
Yes?
Yeah, is there any way these principles can be utilised in VCAT?
Short answer is no, but I mean, in my experience in VCAT, a lot of it's about the vibe anyway. So I mean that with the greatest of respect. And so if you can refer to particular case law and say this is the way it's being done in the superior courts under the Civil Procedure Act, and it makes sense for these reasons, for myself as an advocate at VCAT, I would feel very comfortable putting those sorts of arguments forward as a common sense way to break a particular deadlock. So indirectly, I think the answer is probably yes.
Applications by defendants for summary judgment against the plaintiff have always in the past been very difficult to get up if you've got a statement of claim that discloses the cause of action. Have you guys noticed any relaxation in the situation where, for example, you're acting for a defendant, the defendant client says to you, well, there's absolutely no basis to this claim whatsoever, and can you do something to get this thing brought to a head quickly? Do you think the new rule, do you think the Civil Procedure Act provides that avenue? And do you think that if a defendant in an application puts some of its factual evidence forward and place an onus on the plaintiff to put some factual evidence forward, because traditionally those applications don't involve affidavit material? Yes. Do you think the Civil Procedure Act would allow that to occur?
The answer is yes. There's been a couple of judicial pronouncements to the effect that the court, when faced with a summary judgment application, should go to a reasonable length to allow evidence to be put on, allow submissions to be put, to let the argument take its course and have a fulsome discussion about whether indeed summary judgment ought to be granted. So there is some scope to fully argue such an application by reference to evidence and materials that might go beyond the four corners of the pleadings in the case. But nevertheless, in my experience, acting for defendants who are trying to strike out or get summary judgment against a plaintiff, it is still extremely difficult. And a judge would have to be satisfied that no pleaded variation of the case that's currently before them could have any real prospect of success, and oftentimes such an application will be met with a barrage of evidentiary material to put some kind of flesh on the bones of a pleaded case by a plaintiff to demonstrate that there is a more than fanciful prospect of that case succeeding at trial. And unfortunately, this is where the new test under the Civil Procedure Act maybe hasn't gone that much further than the old test. It's still an extremely difficult thing to do.
The reason I asked, I've just been in America, and in America, the role of the lawyers there is we've just got to get past the summary judgment stage. They fear it. 50% of cases that start in America don't get past summary judgment.
Yeah, well, that's a very interesting observation, and often, not to put too fine a point on it, if I'm drafting a statement of claim and I'm worried about the proper basis certificate and I'm worried about X, Y or Z, a threshold issue in my mind is, will this statement of claim survive a summary judgment application? And that's just a thought process you go through as a pleader. And if the answer is yes, well, that's usually a reasonably good litmus test to the fact that you might be onto an arguable case. If the answer is probably not, well, you'd be putting a strong memo of advice together with that statement of claim saying, guys, don't pull the trigger because you could be going down. Next question. Sorry, Toby?
No, I was just going to say, I think the US experience may be informed, I could be wrong, but by the fact there's detailed depositions early in the proceedings, which, so the evidence will have, and a lot more money will have been spent by that stage, and the evidence, there will have been an opportunity for cross-examination to some extent.
Next question. If I can just add an observation, I think that it's important just to, this paper, we haven't gone through it chapter and verse, so perhaps don't stick it in the filing cabinet when you get back. Have a read of it, because there are some very useful practical tips and tricks in there. But I suppose it would be derelict in my duties if I didn't say, just picking up on something Luke said, brief often and brief early in these matters. I know it's self-serving, but we deal with the Civil Procedure Act all the time. We deal with it in courts, and we know the sort of attitudes that judges have towards this act, and we know how it's being used in practice. So even if you don't brief, pick up the phone, ring your favourite barrister and just say, we've got this thing coming up, or I'm thinking I'm advising a client on a prospective statement of claim. Do you have any views on X, Y or Z? And 99 out of 100 barristers will be happy just to have a chat to you for 5 minutes or 10 minutes and just let you know which way the wind is blowing in the courts at the moment. And that sort of utilisation of the bar, it should be encouraged in my view. Even if it doesn't lead to a back sheet, who cares? As long as this message is getting out there and it's being used in practice, because there are some very powerful tools at your disposal under the new Civil Procedure Act, and a lot of them are not properly utilised. We're getting there, but it's a good piece of legislation, and it really does free you up from the constraints of the rules under the old regime. If nobody else has any questions, I'd just like to thank you all very, very much for attending. You've got the paper, have a read, and I hope it's been informative. Thank you.